Hello everyone. Today we will gain some basic knowledge about contract laws through some basic multiple choice questions. So without wasting any time, let's start with it. The first question is when thing which is commonly the subject of the sale is lost, if the owner cannot with reasonable diligence be found, or if he refuses upon demand to pay the lawful charges of the finder may sell dash. The options are A, when the things is in danger or perishing or of losing a greater part of its value. B. When the lawful charges of the finder in respect of the things found amount to two-thirds of its value. C. Both A and B. And D. None of the above. The correct answer to this question is option C, that is both A and B. That is, when the owner refuses to pay the lawful charges on the finder may sell when the things is in danger or perishing or of losing the greater part of its value, and when the lawful charges of the finder in respect of the things found amount to two-thirds of its value. The next question is the promisee in a contract of indemnity acting within the scope of his authority is entitled to recover from the promisor. Options are A, all damages which he may be compelled to pay in any suit in respect to any matter to which he promises to indemnity applies. B. All costs which he may be compelled to pay in any such suit. C. All sums which he may have paid under the terms any compromise or any such suit. Or D. All of the above. The correct answer to this question is option D, that is all of the above. That means to say, the promisee in a contract of indemnity acting within the scope of his authority is entitled to recover from the promisor all the damages which he may be compelled to pay in any suit in respect to any matter to which he promised to indemnity applies, all costs which he may be compelled to pay in any such suit, and all the sums which he may have paid under the terms of any compromise of any such suit. The next question is a contract to perform the promise or discharge the liability of a third person in case of a default is known as what? Options are A. Contract of indemnity, B. Contract of guarantee, C. Contingent contract, or D. Quasi contract. The correct option to this question is option B, that is, a person to perform the promise or discharge the liability of the third person in case of default is known as contract of guarantee. The next question is the death of the surety operates in the absence of any contract to the contrary as a revocation of the continuing guarantee so far as regards to the future transaction. This is given in which of the following sections? Options are A. Section 131, B. Section 132, C. Section 133, or D. Section 134. The correct answer to this question is option A. That is, this thing is given in section 131. The next question is a continuing guarantee may be revoked for further transaction in which of the following months? Options are A. Before 5 months, B. Within 3 months, C. At any time, or D. May not be revoked. The correct answer to this question is option C. That means at any time. This means that a continuing guarantee may be revoked for further transaction at any time. Next question is when the parties have no intention to make contract but a contract is imposed by law for the performance of the obligation by the parties. This kind of contract is known as what? The options are A. Implied contract, B. Contract by law, C. Quasi contract, or D. Tacit contract. The correct answer to this question is option C. That means to say the contract in which the parties have no intention to make contract but a contract is imposed by law for the performance of the obligation by the parties is known as quasi contract. The next question is tacit contract falls under the category of which of the following? Options are A. Express contract, B. Implied contract, C. Quasi contract, or D. None of the above. The correct answer to this question is option B. That means to say a tacit contract falls under the category of implied contract. The next question is when a contract becomes illegal. The options are A. The it becomes void. B. All arrangement or contract related with it becomes void. C. Performance of the main contract as well as the ancillary or related contract becomes forbidden by law. Or D. All of the above. The correct answer to this question is option D. That is all of the above. This means that when a contract becomes illegal, it becomes void. All the arrangement or the contract related to it becomes void, and the performance of the main contract as well as ancillary or related contract also become forbidden by law. The next question is an express contract is a contract which dash options are A expressed in oral words, B expressed in written words, C where the terms of contract are clear and expressed, or D all of the above. The correct answer to this question is option B. That means to say an express contract is a contract which is expressed in written words and a clear will of performance of the contract is shown between the parties. The next question is a quasi contract is not a contract but A. An alternate of original contract, B. Made by contract in some special circumstances to resemble contract, C. Superstition of original contract made by parties, or D. All of the above. The correct answer to this question is option B. That is, a quasi contract is made by a court in some special circumstances to resemble an actual contract. The next question is an illegal contract means a contract A. Forbidden by law, B. The performance of which is impossible, C. The parties of a contract are unsound mind, or D. All of the above. The correct answer to this question is option A. That is, an illegal contract is a contract which is forbidden by law. The next question is a contingent contract becomes void when options are A. From the beginning as being contingent, B. When the event on which the contract are based becomes impossible, C. When parties of a contract wanted to make it void, or D. None of the above. The correct answer to this question is option C. That is, a contingent contract becomes void when a party of a contract wants to make it void. The next question is Ram, son, forged Shyam's name on a promissory note. Shyam, under the threat of prosecuting Ram's son, obtains a bond from Ram for the amount of the forged note. If Shyam sues on this bond, the court shall options are A. No remedy is available under the law. B. The court must set aside the bond. C. The court may set aside the bond. Or D. None of the above. The correct answer to this question is option B. That is, if Sham sues on this bond, the court must not set aside the bond. The bond will still be applicable. The next question is consideration on objects are unlawful where it is options are A. Forbidden by law or defeat the provisions of any law. B. Which is fraudulent. C. Which is immoral and against the public policy. Or D. All of the above. The correct answer to this question is option D. That is all of the above. This means that the consideration and the objects are unlawful where it is where a contract is forbidden by law or defeat the provisions of any law, where a contract is fraudulent, where a contract is immoral and against the public policy. The next question is a contract which is valid initially, however, ceases to be enforceable subsequently. Then, what happens to the contract? Options are A. The contract remains valid. B. The contract becomes voidable when it ceases to be enforceable. C. The contract becomes void when it ceases to be enforceable. Or D. The contract becomes void since beginning. The correct answer to this question is option C. That means a contract which is valid initially, however, ceases to be enforceable subsequently when the contract becomes void when it ceases to be enforceable.